Another frequently asked question here at our law firm is, how does Florida's seatbelt law affect your personal injury case? Well, Florida law requires all occupants of a motor vehicle to wear a seatbelt. The key is whether that seatbelt is fully operational or not. In the old days, it used to be the burden of the defense if the plaintiff claimed that either a seatbelt wasn't working properly or that the seatbelt was, usually it's a seatbelt not working properly. If the seatbelt's pushed in, but for some reason on impact the seatbelt doesn't hold. It used to be the burden of the defense to prove that there was a problem with the seatbelt. Now it's the burden of the plaintiff. That means that if you had a fully operational seatbelt, you're required to use it. If you were not wearing a seatbelt and you suffer a head injury, the defense could argue that you would not have suffered a head injury had you been wearing a seatbelt and had the seatbelt kept you in place. So the plaintiff would have to have the seatbelt inspected through their lawyer and through an expert hired by the lawyer after the accident, before the vehicle gets repaired. And if the expert shows that that seatbelt was not fully operational or was not working properly, then the plaintiff will be able to argue that either a seatbelt wouldn't have made a difference in this case because it wasn't an operational seatbelt, or the expert might be able to help prove that the person was wearing a seatbelt, but for whatever reason the seatbelt malfunctioned. So those are important things to do. If there's a significant injury, you want to have a lawyer on your case right away and let them hire experts so that we could determine whether there's going to be a seatbelt defense that will be a problem with your case.